Okay. And on that date and time, did you assault or assault and battery Mr. Jose Vites?
Yeah, I threw a book at him.
Okay.
Good morning, Your Honor. Mark Carter, appearing on behalf of Mr. Anderson.
Thank
Christian
you.
Anderson here.
Thank you, Mr. Anderson.
Good morning, Your Honor.
It's still morning. Unbelievable.
Just about, almost.
Yes. We're here for sentencing today.
That's correct, Your Honor. We have no additions or correct. I'm sorry?
I didn't say anything.
Oh, I'm sorry. We have no additions or corrections to make to the report. I do have a couple of comments, if I may.
You may.
Judge, we're going to object to the recommendations E and F. This situation had nothing to do with any drugs or alcohol. This is a situation where my client, he wasn't even necessarily mad. He was hurt because he had just found out that the purported victim in the case, the person whose property got wrecked, was unfaithful to him, and he reacted in a way that he just should not have done. This happened in a home that he was basically paying all the bills for, even though it was her home. And he actually prevented her from being evicted. So he just wanted me to let you know what the context of the background of the case was. But again, there was no drinking or drugs that were involved in this case. My client has no history of drinking or drug abuse. So I would ask the court not to impose E and F. And with regard to any of his outstanding matters, he's advised me that all of them have been taken care of with the exception of one that he's still got to deal with in Livonia.
Thank you. Ms. McDuffie?
So, okay, one thing at a time. When it comes to the recommendations for, I guess, substances, I mean, I leave that to the court and probation, whether, some periodic random monitoring is necessary or not. But I understand, I think this is the time, obviously, to for Mr. Anderson and his attorney to provide some context and speak on, for him to speak on his behalf. But I remember when we took this plea in the courtroom, and Mr. Anderson, I appreciate that he said, I read his statement and that he does take full responsibility for what happened. I remember that Mr. Anderson was so embarrassed about the words that he sent in these text messages that when I read them out loud for him, he couldn't make eye contact with anybody at that time when we kind of went over that. So I appreciate that. I think he regrets that communication. He'll be able to speak on his own behalf in a moment. But I want to be sure that his explanation for the context and the background of that is not an excuse for what happened. I don't believe it is. I don't think that's his intent. But Mr. Anderson is relatively young, and this is a vulnerable period of life where I think that folks' actions don't really register with them fully. So I really hope that it does here. I understand that he feels the weight of having probation in multiple courts, and that can be a lot. But there's some serious offenses here, and in that other case too. So I just really hope that Mr. Anderson, beyond the embarrassment of his actions here, understands that this is not the person that he needs to be, should be, has to be, and hopefully doesn't want to be. The restitution request that we had was already, I think, discussed and agreed upon when we took the plea. So I don't think that there should be any issue there, and the documentation has already been sent in. So nothing else from the people.
Do you have the restitution information?
I do, Your Honor. I have to pull it back up. I know we put it on the record, but we had a receipt for the repairs. I feel like it was somewhere around 100. I'm sorry. I don't want to throw the number out because we read it off before, but let me read the correct number here. We had a receipt for the glass repair on the vehicle. Of course, it doesn't want to load. It was $265.
All right, any response to the restitution from council?
Judge, I haven't seen the documentation, but I take the prosecutor at her word.
And Mr. Hart was not the original attorney. It was a PD once we took the plea and had all these prior discussions. So I can forward that to you.
Thank you. Mr. Anderson, what would you like to say at this time, sir?
I would like to say that I did act out of emotions. I didn't think first. I honestly learned my lesson from this situation. It's been prolonging for a while now. Honestly, I just want this situation to be over with. Honestly, I'm just ready to move on, Your Honor. Like I can't necessarily move on, because it's like I have to come back to court and still think and still like reprocess what actually happened, what transpired, all the emotions that, you know what I'm saying, even occurred to the situation. It still bothers me still, but it's just it was a lot that was going on between me and her, and pretty much that was it. But I apologize, and I apologize for the inconvenience in the court as well. But that's not who I am, and I'm not that type of person. I just acted out of that, out of emotion. I didn't think first. I regret every bit of it. That's why when the prosecutor said I was embarrassed for all the text messages, and she was showing me like I was, because that's not really who I am. You know what I'm saying? It's just how mad I got.
She compromised my
Yeah.
I reviewed those text messages and they are extremely disturbing. So I understand.
I do have. Sorry.
Go ahead.
I do have. I don't want to say away with words, but I'm very graphic and how you want to say descriptive when I speak. But I didn't mean any of those or anything like that. I just was hurt. Just was mad.
You were hurt and you wanted to hurt.
I didn't want to hurt any of them or no one.
I didn't mean physically. I meant emotionally.
Yeah, but I wasn't. Well, now I see that wasn't, like the best.
I mean, if you can't acknowledge that you wanted to hurt her with those words, then we still haven't gotten it. Because the reality was everything you sent about her nephew, about her mom, about her, that was meant to hurt. You cannot deny that.
No, I can't deny that. I wanted some type of, somebody to feel the same way I did, but she also, there was a lot going on with me and her. Like she then gave me multiple STs, been over like all tight, and I still like stayed with her, worked things out, was still holding 2 jobs while we were working. I mean, it was more of a build up. Honestly, my tolerance just ran out, and but everything happened for a reason. And I feel like I'm in a better mental space now than I were a couple years ago or a year back, as far as when this situation occurred. But
I did not want to interrupt, but can we approach your probation really quick? I just want to check on a couple things on the recommendation for him.
Mark. Talk to Mark. Ask for breakouts.
Who's advising you in the back?
that's my mother. I apologize for her. Please, that's contempt. That's contempt.
I'm not advising him. I'm on the phone.
I'm sorry, what did she say?
She can hear. She can
No,
hear.
I'm on the phone. I'm sorry. I'm walking away. Yes.
Don't mind her, Judge. That's my mom. That's my support system. So she's just concerned right now. Her anxiety is through the roof right now. So I apologize for that.
Thank you. supposed to do. You do your counseling, you complete this programming and understand what domestic violence is about, what that looks like. So that you can recognize it and not do it to anyone else and not have it done to you. Okay? Then you need to get your counseling done. And I think you'll come out a better person on the end of this whole thing. And I'll see you in 90 days to make sure you're on track with what you're supposed to be doing. That'll put
Okay.
us January 18th, 2024. And that'll be at 10 o'clock a.m. Okay?
All right. Thank you, Your Honor. Have a good one.
You're welcome. Please contact the probation tomorrow after 9 o'clock. You have their phone number, right?
Yes, it's in the chat. Yeah.
Your Honor, I'll wait for my client, but he's informed me that he wants to withdraw his plea.
Yeah, I already know that. All right, sir, you Devin McGee? And Mr. McGee was previously in court, entered a plea of guilty to the first-degree felony offense of burglary of habitation with the intent to commit aggravated assault. And that was, the agreement was for a cap of 30 years in the institutional division of the Texas Department of Corrections. I have received a pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
I have. I've also received, it looks like a letter from Mr. McGee that I have taken notice of, as well as a couple of, looks like some incident reports from the jail. Have you all had an opportunity to review those?
Yes, Your Honor.
I have. Are there any additions or corrections to that pre-sentence report?
Your Honor, the only additions that I would have is that I've received 2 letters from family members. I'd like to have the court have access to that before making a decision. However, I'd like to read from some of the letters as part of my closing. So I'd like to hold on to them, but then I would like to present them to the court. They're written by 2 close family members. And then further, the only other correction in the pre-sentence report, I guess we need clarification. While the defendant was previously in court and pled guilty, he's informed me this morning that he wishes to withdraw his plea. I let him know that that was up to the court. That's not up to me.
So, Mr. McGee, when you were here before, you were sworn in by the clerk and asked you some very specific questions about your plea and whether or not you were doing it freely and voluntarily, whether or not you did it because you actually did what they charged you with. Obviously, you know that I sat through the trial of your brother, so I've seen all of the evidence against you that would be presented at trial, the videos, all of the things. And so I guess I'm not inclined to let you withdraw your plea. I want to know, though, quickly why you think you want to.
I don't want to withdraw my plea because I was informed. Well, I found out that I can't get probation on this, and I thought I could.
And that's not correct, Your Honor. He is eligible for probation.
You are eligible for probation.
And I have told him.
Affirmative finding of a weapon, I couldn't get it.
What?
Affirmative finding of a weapon, I couldn't get it.
If I make that finding, I can give you anything right now from a deferred probation up to 30 years in prison. That's the range of punishment. So you are eligible for probation. That is an option that I have. So that's whoever has told you that, you're misinformed. That is an option. All right. So I am not going to allow you to withdraw your plea. We're going to go forward with sentencing. Mr. Nix, you may proceed.
Thank you, Your Honor. Your Honor, in reviewing the PSI, obviously the court's seen some of the evidence. It's not good evidence. But the one thing that I think needs to go in Mr. McGee's favor, obviously, is that he did take responsibility. He did plead. Obviously, he's gotten some bad legal information in the jail since we were last here in court. But that shouldn't change the fact that Mr. McGee has had no criminal history other than some traffic citations and a few failures to appear on those traffic citations before this. He's never been in our system. He's never been on probation before, never been sentenced to prison before because he has no criminal history. Mr. McGee did not live a same life that many of us have lived. One of the letters that I received from a close friend, they've known Devin since 2017, so approximately 6 years. Not only did they speak very highly about how Devin would typically put himself before others, and he had a very rough childhood, his mother passed away in front of him at the age of 27. They had no father figure. They were tossed and moved around with their 3 aunts from 2007 to 2017. They both suffered physical, mental, and verbal abuse from 2 of their aunts. Mr. McGee also has a 3-year-old child. He's never really stood much of a chance. He's never had a positive male figure in his life. And that's not my words. Those are the words of close friends and family members that have kind of written on his behalf. They were completely shocked and said that this was out of character for him to partake in this crime. They believed that he was following his brother. They said that this is not who Devin is. Obviously, the court has just what it has in front of them, which is the evidence from that case. And if you just look at the evidence in that case, obviously it's going to give you pause because of the nature of and the violence that took place in the offense. While my client understands the law of parties and he knows that he's just as responsible for whatever his brother did that day, I will say that he was not the aggressor or the main aggressor in the situation. The crime that they committed was despicable, and he would agree with that. He thought that he was going over there to retrieve stolen property. He did not know that his brother was going to start shooting. And in visiting with Mr. McGee, I believe he was also a little afraid and didn't know what to do in the situation once it started going further and beyond what he thought it was going to be. Further, Mr. McGee has told me that he has found religion. He has, one of his write-ups has been because they did not warn the jailer when they were going to pray. So that was one of the write-ups that he had. He also had a jumper malfunction with his buttons. But he says that his newfound religion has given him discipline and peace in his life. He has a son now. He apparently did not know about that. I believe he became aware of that while he was incarcerated. The child was 3 years old. And he would like to have some sort of a life with a son. I would suggest that he get 10 years deferred adjudication probation. And if he messes up even 1 iota, he's got the full range to deal with. So I would suggest that he get 10 years deferred probation, be put on intensive supervision, 0 tolerance, and actually be given a chance, because based on his criminal history, this is not who he is. This is not, and I hope the court doesn't take into account the fact that he tried to withdraw his plea today. I think he got some bad information.
No, I'm not worried about that.
Yeah, he got some bad information in the jail, but he is eligible for probation. I would ask that he get probation, and I'd give Mr. McGee a chance to address the court and explain why he should get probation.
First and foremost, I would like to apologize to the victim in my case. I didn't know, like my lawyer said, I didn't know that my brother was going to go over and shoot him. He told me.
Hang on a second, Devin. Just stop. All right. Y'all went over there with a gun. Hang on. I've watched the video, and you were the one who egged your brother on the entire time. I'm not even sure that your brother would have done what he did had you not been there. Just in his face, do it, do it, do it. I've seen it. Hang on. I've seen it. There's probably nothing you can say right now that's going to help anything, because all you're doing is trying to not take responsibility instead of taking responsibility. Ms. Malfino.
Thank you, Judge. You just took the words right out of my mouth.
Sorry.
You were having no criminal history. We saw him go from 0 to 100 in a matter of 2 hours. On behalf of the Jones family, we appreciate the court taking the time when we addressed Devin's case to carefully consider all of that evidence. This is a unique situation where I don't even feel like I need to argue with the SI. You have everything in front of you. I know you recall it. I know you remember it. I know you know the violence there, and he was responsible for those actions. He needs to be held responsible. I appreciate Mr. Nick's argument. I respect him immensely as a professional. He's just doing his job. The words probation are just absolutely ludicrous for this case. I think Jason said it best when he told you this is not a gift to Devin. This is a gift to them, to let this be over, to stop the nightmare. They deserve to have some peace from this. Your brother's gone for the rest of his life. You better be glad that your exposure is 30 years, and that's not a gift to you. That's by the graciousness of this family. Judge, on their behalf, I would respectfully ask 30 years within the firm of finding the Devin.
Can I present the two letters?
So, I mean, I appreciate Mr. Nick's argument. I appreciate these letters. The problem with these letters is I don't know. I wish if they hadn't seen that the people who are saying what a good person you are and how much remorse you supposedly have, and that you've taken responsibility, saw the video of what happened that night. There's not a whole lot of times here in court that with cases, we have the opportunity to have pretty much every single part of an offense on video, right? And that makes this unique. It's unfortunate probably in some cases that we don't, because probably other people who've done similar things get maybe some breaks that they shouldn't, because we don't have all of that. What you and your brother put that family through that night is the stuff, and I think I've said this before, the family's probably heard me, I know, tell your brother this. This is the stuff out of a movie. This is what makes people have nightmares at night. And you instigated it. You walked with your brother with that assault gun, however far y'all had to walk, knowing you weren't just going to get property, holding a gun. Well, you can object whatever you want, but I know what I saw. I know that you instigated him to keep doing it. You showed him how to take the safety off the gun. I remember all of that. So at this time, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. And at this time, I'm going to find you guilty of burglary of a habitation with intent to commit aggravated assault. I'm going to sentence you to a term of 30 years in the institutional division of the Texas Department of Corrections. I am making an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification, Mr. Nix, that shows this was an agreement. So you have waived any right to appeal. You've also been handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or how long that lasts, you can talk to Mr. Nix. You should thank Mr. Nix. He did an excellent job for you, limiting your exposure, and on behalf of the family, to give you that opportunity to have it limited at 30 years. You're very lucky, and I hope you take advantage of this. When you get out, you're still going to be young. And have an opportunity to live a life, and you can choose. I hope you really have found religion and that you keep that, and that when you get out, you prove yourself that you're not that type of person. All right. Good luck to you. You can go back with the bailiff. Yes. Hang on. Absolutely. Hang on. Can y'all,
Court is calling 2017 CR 4326B, State of Texas versus Emanuel Castro. Can I have parties announced for the record for the state?
Laura Metzel for the state.
Defense?
Stephen Hartwich for Emanuel Castro.
Are you Mr. Castro?
ma'am.
All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
No.
Are you the same Emanuel Castro who was placed on deferred adjudication in 2017 CR 4326B for the offense of possession of marijuana, 4 ounces to 5 pounds on September 6, 2017 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 5. In Bexar County, Texas, the defendant, Emanuel Castro, did then and there fail to report to the supervision officer as directed for the months of June, July, August, September, October, November, and December 2018 in violation of condition number 5.
Just one moment. I don't have that motion. Is that a supplemental?
No, it's on the, oh, sorry, it is on the supplemental, Judge. I apologize.
All right. Mr. Castro, I'm going to show you what's entitled State's Motion to Supplement Pending Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney as well and understand it?
Yes, ma'am.
All right, then to violation of condition number 5, how do you plead, true or not true? State.
And then on violated condition number 5, the second one, Your Honor, in Bexar County, Texas, the defendant, Emanuel Castro, did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, October, November, and December of 2019 in violation of condition number 5.
How do you plead to that, true or not true? I'm sorry, you need to.
And we'll waive the remaining violations, Your Honor.
All right, any objection?
No, Your Honor.
Did you understand by pleading true to violations 5 and 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to 5 and 5?
Yes, ma'am. Sorry.
Court will find 5 and 5 true. Is there a proposed agreement?
Yes, Your Honor, there is. For revocation and adjudication and to proceed forward on sentencing under 1244A for 45 days in the Bexar County Jail.
We're just going to recommend 9 days.
He says on his credit for 45 days. Give me 1 second, Your Honor, to confer on my offer.
Sure. All right, so what are you?
Because his agreement on here says for 45 days, and so I'll just need to verify with him that he changed it to 9 days. Yeah, his offer is for 45 days on here, so I'll need to verify with Daniel because he didn't make any changes on here to verify that he agreed for the JSOC.
All right, so here's the question. Why should I give him 45 days or even 90 days under 1244? Has he done anything?
Judge, as a condition of his bond, you asked him to take sober
Support meetings?
support meetings. He did attend that. Would you like to approach her?
Yes. Any objections to the court?
No, Your Honor. Also, Daniel Escobar from the state of Texas.
So what is the proposed agreement?
It was for 9 days in the Bear County Jail under 1244 judge.
9?
9. And probation was recommending judgment unsatisfied. So
All right. And how much time does he have in?
I think 9 days.
9 days, Judge.
All right, I don't think 9 days is appropriate. So, I mean, you're going to have to go to the Bear County Jail. You understand?
Yes, ma'am.
All right. So what I'll do is I'll grant the motion, find him guilty, and sentence him under 1244. And I'll sentence him to 30 days in the Bear County Jail. And I'll give him credit for any time served. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? All right, you have a limited right to appeal. That's as it relates to the allegations in the motion, not the fact that you were on probation. Do you understand?
That's fine.
All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. So here you go.
Sorry.
No problem.